Welcome to the deep dive.
Hello.
Right, so this is where we take some really critical, often dense, and sometimes pretty dramatic source material.
And we try to pull out the core insights, the things you really need to know.
Exactly. Deliver you the essentials. And today, wow, we are definitely strapping in for quite a constitutional saga.
We really are. It stretches over, 14 pretty turbulent years in Pakistan's early history?
Yeah, a young nation finding its feet. And this timeline, it's not just dates and names, is it? It feels more like a fundamental test case.
It absolutely is. It's
Yeah.
about institutional integrity, really. We're tracing this basic confrontation that, honestly, probably every constitutional democracy has to grapple with eventually.
Which is?
Law versus the gun.
Yep.
Simple as that.
Right.
So this deep dive looks at two very specific Supreme Court judgments, one from 1958, the other from 72. And they basically determined whether a military force could, legally just replace the will of the people.
It's a huge question.
Massive. It's like a masterclass in institutional struggle. We're charting this path from what some call judicial surrender all the way to, judicial redemption.
Okay, let's unpack that. So our focus is squarely on this period, 1958 to 1972,
Correct.
defined by these two big cases, State v. Dasso and then Asma Jalani v. Government of Punjab.
The bookends, essentially.
Got it. And for you listening, our mission here is to give you that shortcut to understanding this really critical pivot point. Why do these two cases matter so much? Why are they still, foundational for Pakistan's constitutional setup?
Yeah, it's about seeing how one court decision effectively empowered future coups.
Right.
And how a later court tried, really desperately, to claw that power back, to put the genie back in the bottle, so to speak.
And the stakes were just enormous.
Existential, really.
Yeah.
Back in 58, the court had to decide, does success in a coup automatically make it legal? Because if the answer is yes, then your constitution isn't worth much more than the paper it's printed on.
Right, it's just symbolic.
But if the answer is no, well, the court's risking everything by saying that to a general with an army.
Yeah, a direct confrontation.
So this 14-year period, it really is like the nation's legal soul-searching. Yeah. A fight for its constitutional identity.
Okay, so let's set the scene a bit more. Pakistan, 1958, it's only, 11 years after independence?
Barely a decade old.
And those early years, they weren't exactly smooth sailing, were they?
Far from it. Political volatility was the name of the game. Governments came and went like a revolving door.
Yeah.
And the constitutional system, the one inherited and then adapted in 56, it just hadn't really sunk deep roots yet.
So, fragile democracy.
Very fragile, struggling to hold. And that kind of situation, it creates a vacuum, doesn't it?
Always does.
Perfect conditions for someone to step in from outside the constitutional lines. Extra constitutional action, as they say.
And the public must have been getting tired of the political mess.
Well, exactly. That's often the justification, isn't it? Public weariness with political chaos opens the door, or at least provides the excuse, for military intervention. Yeah, the instability was definitely the backdrop, the necessary condition, you could say. Civilian leadership had sort of, they'd squabbled themselves into near irrelevance.
And the military saw that weakness.
Perceived it, certainly, and decided to step in. But crucially, this wasn't pitched as just, stepping in to manage a temporary crisis until elections.
Yeah.
No, their action was much bigger. It was designed to fundamentally rewrite the rule book, establish a completely new source of authority.
Okay, so the fuse gets lit in October 1958, and this is where General Muhammad Ayub Khan enters the picture.
Yes, commander-in-chief of the army at the time.
We need to be really clear about just how big his move was. He didn't just, sideline the government for a bit or suspend a few rights.
No. It was far more sweeping than that. Much more. Brutal to the existing legal order. He overthrew the civilian government, yes. But the critical move, legally speaking, was that he abrogated the Constitution of 1956.
Abrogated. Okay, you emphasize that word. Why is that specific term so important?
It's a vital legal distinction. See, you can suspend the Constitution. That means you're pausing its operation, maybe parts of it, maybe all of it, but there's an implication it still exists and might come back.
Right, like putting it on hold.
Exactly. But to abrogate it, that means to abolish it entirely, to repeal it, to wipe the legal slate completely clean.
Wow, okay. That distinction is massive. Abrogation sounds like destroying the state's legal DNA.
That's a good way to put it. It challenges the very idea of legal continuity, of legitimacy. Because if you just suspend it, you're still kind of acknowledging its authority, even while it's paused.
Makes sense.
But when you abrogate it, you're essentially declaring that your power, your authority, comes from somewhere totally outside that previous legal system.
So Ayub Khan wasn't just pausing the law.
No. He was saying his military decree, his martial law, that was the new fundamental law, the new source of everything.
Which immediately creates this huge constitutional...
Of the highest order, suddenly all existing laws, all courts, all appointments, everything's operating in a kind of legal void. Their only anchor is the general's temporary say-so, his fiat.
And then the inevitable question comes up, okay, under what legal authority are you doing all this?
Precisely.
And this is where the courts get pulled in, because actions taken under this new regime were bound to be challenged.
And they were. The specific case that bubbles up to the Supreme Court is State v. Dasso.
Okay.
This was it. The moment of truth for the judiciary.
Yeah.
They had to look at the military commander, who now held all the physical power, in the eye and decide who's really sovereign. Is it the law in the books, or is it the guy with effective control, the gun?
What was the actual Dasso case about? Was it directly challenging the coup itself?
Not directly, no. The case itself was relatively minor, technically. It involved, I think, some tribal dispute or maybe a detention under an older law that the martial law regime had sort of overridden or continued.
But the ruling required them to decide on the bigger question.
Exactly. To rule on the specifics of Dasso's situation, the court first had to decide whether the entire new regime, the martial law itself, was legitimate. Was the law under which action was being taken valid law?
Okay, so the stakes were huge, even if the case wasn't.
Immense.
Yeah.
And this brings us to the judgment, delivered by the Chief Justice at the time, Ahmad.
Well,
And what came out was, well, our source material calls it a chilling judgment. Another way to put it might be legal capitulation. He validated the coup.
wow. Okay, I have to pause here, because that seems so counterintuitive. Isn't the Supreme Court's whole job to protect the Constitution, the document that creates the court?
You'd think so.
So if the general abrogated the source of the court's own authority, how could the court possibly turn around and say, yeah, that abrogation was legitimate? It feels like sawing off the branch you're sitting on.
It does. And the question is, did they rule purely under duress? Was it fear? Or did they actually convince themselves they had a legal justification for it?
What's the consensus?
Well, duress was certainly in the air. You can't ignore the political reality. But they didn't just stay silent or step aside. They provided a genuine, though, as history showed, deeply flawed legal justification. They gave the coup a retroactive stamp of approval.
How? What was the legal hook they hung it on?
The core of this judicial surrender, it lay in a specific legal principle they imported, the Hans Kelsen doctrine of necessity, or more accurately, his theory about the Grund norm.
Kelsen. Okay, we definitely need to spend a minute on this, because you said this was like the intellectual virus.
It became that, yes.
Yeah.
It infected the legal system for the next 14 years.
So for someone listening who, doesn't read Austrian legal philosophers on the weekend, what's the basic idea of Kelsen's theory, and how did Meer use it here?
Okay, Hans Kelsen, major 20th century legal thinker. His pure theory of law tries to understand law scientifically, separate from morality or politics. He said a legal system gets its validity not from being good or just, but from a hierarchy. Each law or norm gets its authority from a higher norm.
Like building blocks. A statute is valid because the Constitution allows it.
Exactly.
Yeah.
And at the very, very top of this whole pyramid sits the ultimate foundational norm, the one you can't question within the system itself. Kelsen called it the Grund norm.
The basic norm, the legal operating system, kind of.
That's a great analogy. It's the ultimate rule that gives legitimacy to everything below it. Usually that's the Constitution itself or the historical event that established it. It's the thing you just established it. Presupposes valid for the system to work.
Okay, got the Grund norm. So where does revolution come in?
Right. Kelsen then asked, what happens if there's a total break? A revolution, a successful coup that completely overthrows the old legal order and its Grund norm.
Yeah.
He argued that if this revolution is successful, and successful is key here, meaning the old system is no longer obeyed, and the new guys have effective coercive control over the territory.
They're actually running the show.
They're running the show. Then, Kelsen said, the legal system itself, out of necessity, has to recognize that a new Grund norm has effectively been established. The whole legal pyramid pivots and now rests on this new foundation laid by the revolutionaries.
Okay, wait. I can see the danger immediately. Was Kelson saying this should happen, that it's morally okay, or was he just describing what does happen from a legal theory perspective?
Ah, you've hit the absolute crucial point, and it's the distinction that Chief Justice Meer arguably missed or chose to ignore. Kelson's theory was meant to be descriptive.
Just saying how it is.
Yes. He was analyzing, look, this is how legal systems seem to adapt or change after a successful revolution has already happened. He wasn't writing a handbook for generals saying, go ahead, stage a coup, and if you win, it's legal,
But the Pakistani Supreme Court took his description.
and used it to prescribe legality. They turned an is into an ought.
How?
They essentially ruled. Because Ayub Khan's revolution succeeded, because he now held effective control, the 1956 Constitution, the old Grun norm, was legally dead and gone. It had been replaced by the martial law regime's decrees, which now formed the new Grun norm.
So success defined by having the guns in control, not by following the old rules, suddenly determined the legal foundation of the entire state.
That's the core argument they adopted, yes. A successful revolution itself becomes a source of law.
If you're powerful enough to overthrow the system and enforce your will, the judiciary must recognize you as the new legal authority.
That's what the Dasso judgment effectively said. Munir and the court, faced with the undeniable reality of a general running the country, they chose pragmatism, or perhaps perceived necessity, over defending the written constitution they were sworn to uphold. They said the old legal order was overthrown, therefore the new military regime had established a new legal order.
But hang on, couldn't you argue Munir was just being practical? Trying to avoid more bloodshed, more chaos? Maybe declaring the general illegal would have just led to the courts being shut down entirely. Isn't that a worse outcome?
That's the eternal debate, isn't it?
Yeah.
The pragmatic argument is exactly that. Resist, and you achieve nothing except maybe getting yourself arrested or ignored, possibly leading to an even bigger legal vacuum if the military abolishes the courts.
Right.
However, the counter-argument, the deep moral and institutional failing identified by critics and later courts, is that the judiciary's one job, its core function, is to defend the Constitution. By prioritizing self-preservation or political convenience, they abandoned their post.
They didn't just accept the reality, they endorsed it.
Critically, yes. By adopting Kelson in this prescriptive way, they gave the coup the intellectual and, crucially, the legal cover it needed, both inside Pakistan and internationally. They basically handed future military plotters the key.
What key?
The key argument.
Yeah.
Just make sure you succeed. Be swift, be effective, consolidate control. And don't worry, the courts will eventually have to recognize you based on the Dasso precedent. Kelson says so.
That is devastating. You've just given a constitutional green light to treason, essentially.
That's how it was seen later. The immediate catastrophic consequence was that this single judgment, State v. Dasso, became, as our source puts it, the sword that justified every military takeover in Pakistan for the next decade and a half. It was the moment the judiciary, the supposed guardian, effectively disarmed itself and empowered the very forces it was meant to constrain. It provided a ready-made legal excuse for usurpation.
A roadmap for future coups.
Precisely. And it fundamentally undermined the idea of constitutional government for a generation.
So Dasso is now the law of the land, handed down by the Supreme Court. And we enter this era where legality itself seems to have been completely redefined in Pakistan.
That's right. For over a decade, from 58 well into the late 60s, this precedent just stood there like a dark pillar in the constitutional structure.
And it forced everyone, judges, lawyers, civil servants, citizens, to operate under this fundamentally flawed premise.
It did. It acted as this kind of impenetrable legal shield for anything the military regime wanted to do. Think about Ayub Khan's agenda. He wasn't just content ruling by decree forever.
No, he wanted a new system.
Exactly. He wanted a new constitution, one that suited him, one that was, safe from messy politicians, that cemented his own power, maybe even gave the military a permanent institutional role.
And he brought one in, didn't he? The 1962 Constitution.
He did, a highly centralized presidential-style system, very different from the parliamentary 1956 one he'd abrogated.
So how did Dasso provide the legal cover for him to just write a new constitution from scratch? Surely the old constitution had rules about how to amend or replace it.
It did. But remember, Ayub Khan hadn't amended the 56 Constitution. He'd abrogated it, wiped it out.
Oh, right. Slate was clean.
According to the Dasso ruling, yes. Because the Dasso court said the successful revolution itself was the new source of law, the new Grun norm.
Then the revolutionary leader, Ayub Khan, was the sovereign authority.
Precisely. And as the new sovereign, he was entitled to establish a new legal order. That included promulgating a brand new constitution, ex nihilo, literally, from nothing.
So the 1962 Constitution, however undemocratic or tailored to Ayub Khan it might have been.
Was deemed perfectly legal because it was given by the authority that the Supreme Court, via DASO, had already recognized as legitimate.
Okay, that's the aha moment right there. That's why military rule wasn't just a matter of force for so long. It had this veneer, this stamp of judicial approval.
Exactly. It wasn't just that the general had the tanks. It was that the highest court in the land had provided the theoretical framework, saying, yes, this new system, born of force, is now the legal system. And that forces compliance down the chain. Lawyers have to argue within it, judges have to rule based on it, citizens have to obey it.
This must have created a terrible cycle.
It did. A cycle of justification.
Mm-hmm.
After 1958, the legal test for any future takeover became depressingly simple. Did it succeed? Did the new guys gain effective control?
Yes.
Right. Therefore, is it legal?
Yes, according to DASO.
Exactly. And this meant the judiciary's first duty, as it was later put, wasn't to the Constitution anymore. It was to, well, convenience, practicality.
Who rocks a boat?
Pretty much. The court was effectively saying, look, we can't have a clash between the reality on the ground, the generals in charge, and the law in the books. So we have to bend the law to fit the reality.
But surely that paralyzes the judiciary. Their whole purpose is justice, upholding the law. But the highest precedent forces them to ignore the source of the law, the Constitution, if it conflicts with power. What was the mood like in the courts during those 14 years?
From what sources suggest, it was a climate of, well, judicial malaise.
Yeah.
Maybe even a kind of internalized fear or resignation. Judges were, in effect, constitutionally neutered.
Yeah.
Imagine being a lawyer trying to challenge, say, an arbitrary detention order issued under martial law.
You'd file a petition.
Right. And
Right.
the government lawyer stands up and says, Your Honor, the martial law regulation under which this person is held flows from the authority of the chief martial law administrator, whose regime's legitimacy was established by this court itself in State v. DASO. End of argument.
Unanswerable.
Pretty much. The court seemed to prioritize avoiding a confrontation they felt they couldn't win, or maybe they genuinely feared creating a chaotic void of authority if they challenged the regime. But either way, the result was the same. The abrogated Constitution remained undefended by its designated defenders.
It sounds like the whole legal profession, judges included, must have been living with this massive cognitive dissonance.
That's a good way to describe it. Politically, many might have felt the military rule was wrong or at least problematic, but legally, according to their own highest court, it was right.
They confused what is with what ought to be.
They absolutely did. They saw the political reality, the generals in charge, and they allowed the legal reality to be reshaped to match it, using Kelsen as the tool.
And the irony, did Ayub Khan himself eventually fall foul of his own system?
In a way, yes.
Mm-hmm.
The ultimate proof of the DASO loophole's power came when Ayub Khan finally stepped down in 1969 after massive protests against his rule.
Did he hand power back to civilians?
No. He didn't follow the procedures in his own 1962 Constitution for succession, like handing power to the Speaker of the National Assembly. Instead,
What?
he handed power directly to another general, the Army Chief, Yahya Khan. And what did Yahya Khan immediately do?
Let me guess. Abrogated the 1962 Constitution.
Bingo. Abrogated Ayub's Constitution, the very one DASO had legitimized, and imposed martial law all over again.
So Ayub used the DASO precedent to legitimize his rule, and then when he left, he ignored his own rules and used the same extra constitutional logic, just hand power to the next strongman, ensuring the cycle continued.
Perfectly put. That's the horrifying legacy of DASO. It wasn't just a one-off justification for 1958. It provided the implicit mechanism for the next coup, the next abrogation, the next imposition of martial law by General Yahya Khan in 1969. The legal basis was exactly the same.
Yeah.
Kelsen, success, DASO.
Wow, okay. Our source material brings up a really profound point here. It says the law may stumble under fear. It suggests the DASO decision wasn't just cold legal logic, but maybe rooted in genuine fear. Or perhaps just extreme pragmatism.
I think you have to acknowledge the fear factor, especially in 58, when the alternative to validating the coup might genuinely seem like chaos or even personal danger.
Yeah.
It takes incredible courage for judges to stand firm. But that decision, whether born of fear or pragmatism, it set this terrible norm. It taught the military and everyone else that the legal system will bow if the power confronting it is overwhelming enough. Be successful and you'll be declared legal.
The institution paid a huge price for that pragmatism.
It sacrificed its core purpose, its independence, for 14 long years. It essentially created this gaping hole in the rule of law.
A hole that desperately needed to be closed.
Exactly. And history, as the source notes, was preparing its revenge, which sets us up perfectly for the massive shift that finally came in 1972. The political context changed, and that finally allowed the judiciary to act.
Okay, let's jump forward. 1972. The whole political landscape in Pakistan is radically different now.
Completely transformed. The key event, of course, is the disastrous 1971 war, which led to the secession of East Pakistan and the creation of Bangladesh.
And General Yahya Khan's regime, the one that took over from Ayyub, the one also operating under that DASO-validated martial law.
It collapsed, utterly discredited by the military defeat and the loss of half the country.
And that collapse, that created the opening.
That created the essential space politically and morally for change. The military was, for perhaps the first time, deeply unpopular and on the defensive. There were massive calls for accountability. Civilian rule was being restored, albeit under Zulfikar Ali Bhutto, who initially took over as President-in-Chief Martial Law Administrator, paradoxically.
But the key thing is the previous military regime had fallen.
Yes. And when a regime that seized power unconstitutionally falls, the successor government, and crucially the courts, suddenly have the freedom to look backward and scrutinize the legal basis of the regime that just got overthrown.
The immediate threat is gone.
The immediate threat is gone. The fear factor is dramatically reduced. And this provided the judiciary with the context, a moment of relative non-coercion to finally reevaluate the original sin, the constitutional mistake made back in 1958.
And the test case that allowed them to do this was Ahmad Gilani v. Government of Punjab. We heard the name. Who was Ahmad Gilani? What was her specific situation?
Ahmad Gilani wasn't herself detained, but she was the daughter of a well-known political figure, Malik Ghulam Gilani. He, along with another prominent person, Altaf Gauhar, had been locked up, detained without trial.
Under what authority?
Under specific martial law regulations issued by General Yahya Khan's regime.
Okay.
So, the case that reached the Supreme Court was fundamentally a habeas corpus petition. It was challenging the legality of these detentions.
A direct challenge to the power of the martial law regime to just lock people up.
Exactly. It wasn't some abstract legal theory discussion this time. It was about real people, citizens, whose fundamental right to liberty had been taken away by orders flowing from a regime whose own legitimacy was based purely on military force and the DASO precedent.
The logic being, if Yahya Khan's martial law itself was illegal,
then any orders, any regulations, any detentions made under it were also illegal. Fruit of the poisonous tree. Those people were being held unlawfully.
this feels like a moment of huge judicial opportunity, a chance to defend basic human rights while simultaneously fixing the deep constitutional problem.
It absolutely was. And this time the Supreme Court, now led by a different Chief Justice, Hamid Rahman, took a radically different path.
The source says the court rose to its conscience.
I think that captures it well. This is the moment often described as judicial repentance. Chief Justice Rahman and his bench clearly understood the immense damage DASO had done over 14 years. They knew the court itself had, in 1958, essentially blessed the death of constitutionalism.
And they saw this as the chance to undo that.
To fix it. To set the country's constitutional path straight again. And they knew they had to be bold. They had to explicitly admit that the previous court, their predecessors, had made a grave error.
And the political climate allowed it, the backlash against the military after 71.
It more than allowed it. It almost demanded it. The public mood was hungry for accountability, for a return to some kind of legal normalcy after the trauma of the war and dictatorship. This political wind at their backs made judicial courage not just possible, but perhaps even necessary for the court's own legitimacy going forward.
So the pendulum swings back. Hard.
Very hard.
Yeah.
They didn't just, distinguish DASO on some technicality or gently disagree with it. They went for the jugular. They had to wipe the slate clean.
So what was the core ruling? What did they declare about Yahya Khan and his power?
The declaration was, well, it was stunning in its directness, unequivocal, powerful, historic, really. Chief Justice Hamid Rahman, writing for the court, declared, and this is the key phrase, General Yahya Khan was a usurper. His martial law was illegal and void ab initio.
Okay, let's break that down. Usurper, that's strong language.
Very strong. It's a moral judgment, a political denunciation. It brands him, and by implication, Ayub Khan before him, not as a revolutionary leader legitimized by success, but as someone who illegally seized power that wasn't his. A traitor to the state, essentially.
And then the legal knockout punch, void ab initio, you mentioned that earlier. Why is that phrase the masterstroke that really dismantles the whole Dasso legacy?
Void ab initio. It literally means void from the beginning.
Right.
Think of it like this. If a contract is declared void ab initio, it means that legally that contract never existed, not even for a second.
Yeah.
All of the signatures, the stamps, the actions taken under it legally, they're all null.
So the court wasn't just saying Yahya Khan's rule became illegal when he fell from power.
No. Crucially, they were saying his rule was never legal. Not for a single moment. Not from the instant he took power in 1969. It was illegitimate from the absolute start.
And if Yahya's 1969 takeover was illegal from the start,
Then the same logic had to apply retrospectively to Ayub Khan's original 1958 coup, which Yahya's coup was built upon. The whole foundation was rotten from the beginning.
so Gilani legally erased the legitimacy that Dasso had supposedly granted 14 years earlier.
Completely. It retroactively canceled the application of the Kelsen Doctrine in Pakistan. It said that whole theory about success creating legality, that was a mistake. It doesn't apply here. It never applied here. So yes, it was a complete repudiation of the idea that a successful coup could ever create a valid legal order under Pakistan's constitutional framework. By declaring the martial law void ab initio, the court was effectively saying that the true supreme law of the land, whether it was the 56 Constitution abrogated by Ayub or the 62 Constitution abrogated by Yahya, had actually remained the de jure supreme law throughout that entire period, even though it was physically suppressed.
So the general's decrees weren't laws at all.
They were merely commands issued by unauthorized individuals, criminal commands, essentially. The legal vacuum they claimed to fill was just an illusion of legality. The real law had been dormant, waiting to be reasserted.
This must have sent absolute shockwaves through the military establishment.
You have to assume so. They'd operated for 14 years under the belief, backed by the highest court, that their authority stemmed from their effectiveness, from their success.
And now that same court was saying, nope, you were usurpers all along.
Everything you did under martial law, every political act, every detention, every regulation, every land grant was technically illegal because your foundational authority was illegitimate. It essentially declared the entire period of military rule from 1958 to 1971 as the actions of an illegal enterprise.
That's a massive institutional risk for the court to take, even with the military weakened.
Huge risk. But Chief Justice Rahman and the bench must have realized that without this, it was a complete philosophical turnaround. Let's dig into the specific legal principles, the ratio decidendi, the core reasoning that Chief Justice Rahman laid down. Because these weren't just for this one case. They were meant to guide future courts and prevent the Dasso mistake from ever happening again.
Okay, what's the first big one?
Well, the first and most direct step was explicitly overturning State v. Dasso. Just wiping that precedent off the books.
They call it out by name.
Oh, absolutely.
Yeah.
They went through Munir's judgment, particularly his reliance on Kelsen, and systematically dismantled it. Justice Rahman argued quite forcefully that Kelsen's theory was purely descriptive of de facto power shifts. It wasn't a source of de jure legality. He basically said it was a category error, a mistake, to import this foreign academic theory to justify tearing up Pakistan's own constitution.
So, Kelsen out, Dasso overturned.
And with it, the judgment effectively buried the doctrine of necessity, at least in words.
Okay, that phrase again, at least in words. Why the caution? Why did the source and maybe the court itself feel the need for that little qualifier?
It feels like a moment of judicial realism, doesn't it?
Yeah.
It acknowledges the practical limits of judicial power.
How so?
The court can write the most brilliant, legally sound judgment declaring coups illegal, treasonous, void ab initio. They can define the law perfectly. But the court doesn't have an army. It can't physically stop a tank rolling down the street.
Right. Enforcement is still an issue.
Enforcement is still the issue. So, at least in words, acknowledges that, look, future generals might still try to stage coups. Political reality is messy. But the qualification also draws a line in the sand. If they do, they will never again have the legal cover that Dasso provided. They will be acting in clear, judicially defined violation of the Constitution. Their actions will be branded illegal from the start.
So the court sets the legal standard even if it can't guarantee political compliance.
Exactly. They define the law. It was then up to other parts of the state, the executive, parliament, maybe even the people, to find ways to defend that law.
Okay, makes sense. Let's move to the core positive principles established in Gilani. You said there were three main ones.
Yes, three foundational pillars emerged from the reasoning. Principle number one. A successful coup cannot confer legality on an illegal act.
That's the direct hammer blow against Dasso's logic.
Absolutely. The court just flatly rejected the idea that effectiveness equals lawfulness. Legitimacy, they argued, can only flow from the established constitutional procedures, from the law itself, not from the brute fact of who holds power.
Might doesn't make right.
Precisely. They use analogies like, if a gang of armed robbers successfully takes over a bank, holds it for days, starts running it, does their success make the robbery legal?
Of course not. It's still robbery.
Right. And similarly, the court argued, the successful usurpation of state power, however effective, remains what it always was, an illegal act. High treason, in fact, under most constitutional systems. Success doesn't wash away the crime.
So it firmly separates the fact of power from the right to power.
Yes. Power might get you into the presidential palace, but only the Constitution can give you the legal authority to be there and command the obedience of the state, including the courts. This principle was designed to starve future coups of any potential legal oxygen.
Okay, principle 1. Success, illegality. What's principle 2?
Principle 2 is profoundly democratic. Sovereignty belongs to the people, not to the sword.
Ah, okay. This sounds like it's defining where ultimate authority actually comes from.
Exactly. It's a direct challenge to the inherent authoritarianism of military rule. The military might see itself as the ultimate guarantor or savior of the nation, but the court said no. Ultimate power, ultimate sovereignty resides with the citizens, the people of Pakistan.
And the Constitution is how the people express that sovereignty.
Precisely. The Constitution is the embodiment of the people's collective will. Any attempt by one person, one general, one group to unilaterally seize that sovereignty by force is inherently illegal because it violates that fundamental political compact between the state and its citizens.
So this makes the Constitution not just a legal document, but a sacred expression of the popular will.
Yes, it can't just be torn up by whoever happens to have the guns at any given moment. It reestablishes that power flows up from the people, through their constitution, to the institutions of the state, including the military.
So the military serves the Constitution, not the other way around.
That's the core message. The military cannot be the sovereign. It is merely an institution subject to the people's sovereign law, as expressed in the Constitution.
Okay, that's powerful. Success doesn't make legality, and sovereignty rests with the people. What's the third principle?
Principle 3 feels like the judiciary talking to itself, correcting its own past and setting its future course. The judiciary's first duty is to the Constitution, not to convenience.
This hits Dasso right where it lived, that argument about pragmatism and avoiding chaos.
Directly. This is perhaps Chief Justice Rahman's most pointed legacy from this case. It's a direct rebuttal to the fear or the perceived necessity that seemed to drive the Meer court in '58.
What's the core message here?
Rahman is saying, judges cannot take the easy path. Our job isn't simply to rubber stamp whatever the political reality is just to keep things running smoothly or to avoid a fight with the executive or military. Our highest duty, our non-negotiable obligation, is to uphold and defend the written Constitution. Full stop.
Regardless of the consequences, regardless of the danger.
Regardless of how inconvenient or politically risky or even personally dangerous that might be, this principle reasserts the court's independence. It's not just another branch of government beholden to whoever's in power. It's the ultimate guardian of the foundational law itself.
It gives judges a mandate, maybe even a command to stand firm, even if it means personal risk.
It does. It defines judicial courage not as an optional extra, but as a core requirement of the job when the Constitution's under threat. So, taken together, these three principles.
Success, legality, sovereignty is popular, duty is to Constitution.
They fundamentally restored the supremacy of the Constitution in Pakistan's legal framework. Gilani established, as firmly as judicial words can, that military coups are treasonous usurpations, and the courts must declare them as such, regardless of the usurper's temporary success or power.
And did this get reflected in the actual Constitution later?
Yes, crucially. The next Constitution, adopted in 1973 under Bhutto, specifically incorporated the spirit of Gilani. It included, and still includes, Article 6, which explicitly defines the abrogation or subversion of the Constitution as high treason. That's a direct legacy of the judicial stand taken in 1972.
When you look at that whole arc from the depths of 1958 with Dasso to this powerful restoration in 1972 with Gilani, it really does feel like the defining moment, the turning point in Pakistan's constitutional story.
It absolutely is. It wasn't just one case reversing another. It was, as we said, a profound moral victory for the judicial institution itself. It showed that courts can correct their own gravest errors, even if it takes time.
And that act of correction, that judicial repentance, had a lasting impact.
The source suggests it inspired future generations. Think about the burden the judiciary must have felt carrying the Dasso legacy for 14 years, knowing they'd essentially enabled military rule. By finally confronting and overturning it, the Rahman court gave future judges not just the legal precedent, but also the moral courage to potentially stand up to executive overreach or military pressure.
It showed that institutions can learn, that they can redeem themselves.
Exactly. It sent a powerful signal that the long-term integrity of the judicial process, adherence to the Constitution, mattered more than short-term political stability or avoiding confrontation. It showed that institutions, like people, can admit mistakes and try to make amends.
And the core principle that Gilani immortalized, it echoes far beyond Pakistan, doesn't it? That simple, fundamental idea, no one is above the Constitution.
That's the bedrock. That principle is now embedded in Pakistan's legal DNA, thanks to Gilani and the subsequent 1973 Constitution. Even if future generals did attempt coups, and, spoiler alert, they did, they could no longer claim the kind of quasi-legitimacy Dasso had offered. They would be acting with the clear judicial stain of usurper and traitor already upon them from the outset.
So Gilani became the weapon the judiciary could wield.
It's the constitutional shield, yes. Even when later military rulers tried to bring back versions of the doctrine of necessity to justify their actions, the ghost of Ahmad Gilani was always there, providing the powerful counter-argument. Your actions are fundamentally illegal, ab initio. It set the enduring standard. Everyone, no matter how powerful, no matter the uniform, is subject to the Constitution. The court gave itself the mandate and the legal tools to hold power accountable to law.
Let's go back to that concluding thought from our source, because it really sums up the whole 14-year journey. The law may stumble under fear, but justice always finds its way back, even if it takes 14 years. It's a hopeful message, but also, why 14 years? Why did justice have to wait so long? Couldn't a court between 58 and 72 have found the courage?
It's a critical question. The 14-year delay really highlights the interplay between law and political reality. The court in 1958 was operating under the immediate shadow of a successful, consolidating military coup. The perceived threat was immense.
Right, the duress factor we talked about.
Exactly. The court in 1972, however, was operating in the wake of that regime's total collapse and public disgrace. The fear factor was drastically lower, and the political winds were blowing strongly against the military and towards accountability and constitutionalism.
But constitutional courage sometimes needs a political window to open.
It often seems that way. Institutional change, especially correcting a major past error, often requires a conducive political environment that reduces the immediate risks of confrontation. The 14-year wait underscores that painful lesson about pragmatic legality, sacrificing core principles for what seems like necessary convenience at the time. Well, it usually comes back to bite you. Those principles will eventually demand to be heard, and the cost of restoring them later might be far higher than the cost of defending them in the first place.
And importantly, Gilani, by declaring the past regime illegal from the start, it didn't just fix the theory right. It had practical consequences.
It potentially did. By rendering the martial law void ab initio, it theoretically opened the door for the new civilian government under Bhutto to undo specific illegal acts of the past regime, and even potentially prosecute those involved in the usurpation under the revived constitutional order. It provided a legal basis for accountability.
Setting a deterrent, maybe?
At least in theory, that's the hope. The whole saga, Dasso to Gilani, really becomes this essential case study for any democracy trying to manage the delicate balance between civilian control and military power.
Yeah.
It shows just how pivotal the judiciary's role is in moments of crisis. A court can buckle, provide legal cover for authoritarianism, and condemn a country to years of extra-constitutional rule.
Like Dasso.
Or it can stand firm, uphold the Constitution, and secure the legal foundations for democratic governance for decades to come.
Like Gilani.
Even if it means admitting the judges who came before them got it catastrophically wrong.
Hashtag tag outro.
Wow.
Yeah.
That was quite a journey, an incredible deep dive through 14 years that fundamentally shaped Pakistan's constitutional identity.
It really covers the full spectrum, doesn't it?
Yeah, we went from that moment of judicial validation for General Ayub Khan back in 1958, the Dasso case.
That moment of surrender to the Kelson Doctrine, misinterpreted or misapplied.
Right. All the way to 1972, Chief Justice Rahman and the Ahmad Jilani case, this revolutionary rejection of military legitimacy. The judicial repentance, the restoration.
So if there's one key takeaway for you listening, one nugget of knowledge from this whole deep dive, what should it be?
I think it has to be that crucial distinction we kept coming back to. The difference between raw power, like a successful coup, a general in charge, a new reality forced onto the country.
He is.
He is. And genuine legitimacy, the ought which, in a constitutional system, must flow only from the Constitution itself, the expression of the people's will.
And the courts eventually chose legitimacy.
They eventually decided, emphatically in Jilani, that legitimacy must prevail over temporary power, even if it took 14 difficult years of living with the consequences of the opposite decision.
Those 14 years taught a hard lesson.
Yeah.
Even when military rule seems solid, maybe even effective for a time, the legal truth, the constitutional truth, it doesn't just disappear.
It stays dormant, waiting for the right moment, the right court, the right political climate to be reasserted. The judiciary ultimately declared that power must submit to law in a republic.
Okay, and that brings us, as always, to a final provocative thought for you to mull over, something building on what we've discussed.
Right. The source material itself noted, quite starkly, that even after Ahmad Jilani seemed to settle the matter, even after it immortalized the principle of constitutional supremacy, coup returned.
Proving that a legal principle, no matter how brilliantly articulated by a court, isn't a magic shield against political reality.
Exactly. So here's the question. If the judiciary, through a landmark ruling like Jilani, definitively defines a military takeover as illegal, calls the leader a usurper, and restores the Constitution's supremacy, what else needs to be there? What actual practical, functional mechanisms must exist within a state to ensure that judicial ruling is enforced against the sword?
Right. Because the court declared the law but couldn't stop future tanks. So how does a state make sure it doesn't keep needing these moments of judicial repentance every generation or so? If the judges can only say what the law is, who makes sure the law is obeyed? Is it the executive, parliament, the police, civil society, the military's own internal code? How do you bridge that gap between the legal declaration and the political enforcement?
How do you give real teeth to the law when it's facing down brute force?
That's the challenge, isn't it? And that's the question we'll leave you with today. How do you make judicial victories stick?
Something definitely worth thinking about. Thanks for joining us for this deep dive.
We'll catch you next time.